Good afternoon, everybody. I am Horace Anderson, the Dean here at the Elisabeth Haub School of Law at Pace University, and I'd like to welcome you to the 2024 Blaine Sloan Lecture on International Law. We are pleased and honored today to have with us as our Blaine Sloan Lecturer, the Honorable Margaret M. deGuzman, the James E. Beasley Professor of Law and Co-Director of the Institute for International Law and Public Policy at Temple Law School. Professor deGuzman is also judge of the Residual Mechanism for International Criminal Tribunals. Drawing upon this role, today she will speak on the promise and perils of international criminal law. The Blaine Sloan Lecture has been an annual tradition at Haub Law since it was first established, the lecture that is, in 1988. It was created in honor of F. Blaine Sloan, who was instrumental in developing the International Law Studies program here at the law school. A member of the United Nations Legal Office for 3 decades and director of the General Legal Division, Professor Sloan contributed significantly to the development of both public and private international law. Blaine Sloan represented the Secretary General at the 1978 UN Conference on the Carriage of Goods by Sea, at the sessions from 1969 to 1978 of the UN Commission on International Trade Law, or UNCITRAL, and at the 1966 to 1978 sessions of the Legal Subcommittee on the Peaceful Uses of Outer Space. His UN service involved him in that organization's work on the war in Vietnam, relief for Palestinian refugees, peacekeeping in the Middle East, and the UN Commission on Korea. He also served as legal advisor to Security Council sessions held in Africa and Latin America. Today, Professor deGuzman is joining a long list of distinguished Blaine Sloan lecturers who we've been privileged to welcome over the past 36 years. Some of these notables include Jorge Islas Lopez, Consul General of Mexico in New York, Professor Sarah Cleveland, Lewis Henkin Professor of Human and Constitutional Rights at Columbia Law School, and Dr. Boris Kozolczyk, President and Executive Director of the National Law Center for Inter-American Free Trade, among many others. Professor deGuzman, welcome. We look forward to learning from you today. Now, with a more formal and much better introduction of our speaker, Professor Sasha Greenewalt.
Thank you. So it's my pleasure to introduce Professor deGuzman. As Dean Horace Anderson already mentioned, Professor deGuzman is the James E. Beasley Professor of Law and co-director of the Institute for International Law and Public Policy at Temple Law School. Professor deGuzman received her PhD in human rights from the National University of Ireland, Galway. Her law degree, a JD from Yale Law School. She also has a master's from the Fletcher School of Law and Diplomacy and a bachelor's degree from Georgetown University's School of Foreign Service. Before joining the Temple faculty, Professor deGuzman clerked on the Ninth Circuit Court of Appeals. She practiced criminal law in San Francisco, specializing in criminal defense. She served as a legal advisor to Senegal's delegation at the Rome Conference, where they negotiated the treaty establishing the ICC, the International Criminal Court. And she was also a law clerk in the Office of the Prosecutor of the International Criminal Tribunal for the former Yugoslavia, and in addition, a Fulbright scholar in Senegal. As a law professor, Professor deGuzman has been a prolific scholar and a leading major voice in the field of international criminal law. She has published many very well-received law review articles, has served as a co-editor of a book, The Elgar Companion to the International Criminal Court, and then also Arcs of Global Justice, Essays in Honor of William Shabas, published by Oxford University Press. And more recently, she published her own book, her own monograph with Oxford University Press entitled Shocking the Conscience of Humanity, Gravity and the Legitimacy of International Criminal Law. I can say on a personal note that Professor deGuzman is an absolute wonderful colleague, a friend, a wonderful human being. And, I think when we think about networks of colleagues and friends, and as you're heading into the professional world, how all of that works, Professor deGuzman is one of those people who serves as a hub, bringing together the rest of us who are the spokes. And some of my fondest memories of working also in this field have involved events hosted by Professor deGuzman at Temple Law School, where I have been lucky enough to be invited and to gather together with all our other colleagues and friends in the field. So now, more recently, we have the title of professor, we have doctor. Professor deGuzman has added a new title. She is now the Honorable Margaret deGuzman, a sitting judge on the residual mechanism for international criminal tribunals. And if you don't know what that is, there were two very, very important international criminal tribunals established in the early 1990s, the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda. They were created by the UN Security Council. When their mandates ended, there was still legacy work to be done, including some trials, appeals. The mechanism is the successor court to both of those institutions. And I will note in particular that the Honorable Professor deGuzman has served on a trial chamber at the mechanism in the case of Kabuga, who was accused of participation in the Rwanda genocide, in particular as a financier of the media organizations that were inciting genocide in Rwanda. And that case presented both to Professor deGuzman and her colleagues some very interesting challenges regarding Kabuga's capacity to stand trial or lack thereof. I wanted to mention that I understand that's not going to be the topic of the lecture today, but you can Google that. It's a very interesting case. So without further ado, I'm looking forward to the lecture, and we will have time for questions afterwards.
Thank you so much, Sasha, for that very generous introduction. I particularly liked the wonderful human being part. And I'll just say, yeah, right back at you. And you all know what a wonderful human being Professor Greenewalt is, so I don't need to tell you about that, but I'll give you one quick story by way of example. We've been colleagues for a long time and also friends, but we haven't had a lot of occasions to see each other outside of the academic circles that we travel in. So I mentioned to him, this is now 10 years ago, I think, something like that. It's been a while, that I was going to take a sabbatical in Rome. And he immediately said, oh, well, you should go stay at my place in Croatia while you're there. Little knowing that I always take people up on their offers to stay in exciting places. So if any of you have anywhere fun that you'd like me to stay, please let me know. Anyway, we went, my family and I ended up going. He wasn't able to be there because I was on sabbatical, so he was here teaching and stayed there for 2 weeks, and it was amazing. And sort of just one example of his generosity and kindness, but that introduction was another. I also want to thank the organizers, Rachel, Melissa, and Renee for their organizational efforts, Dean Anderson and Sasha for the invitation, and the Sloan family for sponsoring this lecture series. I have to note to begin that I'm speaking in my individual capacity, not as a judge of the International Residual Mechanism for Criminal Tribunals. And as you know, the topic of this lecture is the promise and perils of international criminal law. ICL has been one of the fastest growing areas of international law over the past several decades. And it's garnered a huge amount of attention, even more so since Russia invaded Ukraine a couple of years ago. it's been in the news constantly. And so I think it's a particularly important topic to think about whether it merits all of the attention and all of the resources that it's receiving. And so that's what I'm going to talk about a bit today, and then I'll look forward to hearing your questions. I'm going to start by giving a brief overview of international criminal law in case some of you aren't very familiar with it, the topics it covers, the institutions, a brief history. Then I'm going to talk about the promise of ICL, the ways in which I think ICL has the potential to contribute to a more just international or global society. And then some of the perils, the flip sides of some of the promise, ways in which ICL can also potentially harm the global community and its members. And then I'll just briefly conclude by giving you some ideas about where I see the future of this field going. So first, what is international criminal law? Well, obviously that could take a lecture, a book, a course in itself. But for purposes of this talk, I'm going to define international criminal law as a set of institutions, laws, rules, and norms designated to regulate certain kinds of conduct. And the kinds of conduct included in the scope of that regulation are also themselves important subjects of debate, things that Professor Greenawalt and I have both written about. But for purposes of this talk, we're just going to posit that the appropriate subjects of international criminal law are what are often referred to as atrocity crimes: war crimes, crimes against humanity, genocide, and the crime of aggression. These are crimes that, at least arguably and some of the time, concern the international community as a whole, and so merit the attention, the resources, the institutions of international criminal law. The primary sources of international criminal law, like international law more generally, include treaties. So, for example, the Rome Statute of the International Criminal Court is a treaty. The sources also include statutes of other courts set up, for example, by the Security Council, which is the case of the court where I'm a judge, the International Residual Mechanism, which is the successor court to the Rwandan and Yugoslav courts, as Professor Greenawalt mentioned. And because those were set up under the Security Council's Chapter 7 mandate to do things in the interest of peace and security, the statutes were developed under the aegis of the United Nations rather than by treaty. But other sources that the courts rely on quite a lot include customary international law, the practice of states followed out of a sense of legal obligation. International criminal law is a very new area of international law, so there aren't a lot of treaties. In fact, you may be surprised to know that while there's a treaty governing the crime of genocide, and there are treaties governing war crimes, there isn't a treaty for crimes against humanity yet. But it's something that many people are hard at work on, and indeed states are considering it now at the United Nations, so we may have one soon. But just to give you a sense of how this area is one that is still very much under development. So in addition to customary international law, there are general principles of law that are often put forth or come to light through the practice of states in their criminal laws. So that also can form a basis for decision-making before international criminal courts and tribunals. So those are the primary sources. Where is it practiced? Well, you've heard for sure of the International Criminal Court in The Hague, which is sort of the primary institution that practices international criminal law, but there are also a lot of other courts. So the residual mechanism, there are some hybrid or internationalized courts, so distinct from the ICC or the mechanism in that those are more fully international. They were set up under international law by international organizations or by treaty. Hybrid courts are set up in conjunction with a state where the crimes were committed, and in some cases, an international organization, in some cases, a regional organization. And so those involve some international law and sometimes domestic law. some international personnel, domestic personnel. So they're a mix or a hybrid of different kinds of laws and personnel. And then there are some what I call regionalized courts set up in conjunction with regional organizations. And here in particular, I think about the extraordinary African chambers in the courts of Senegal, which is actually a subject of a book that I'm working on with a colleague, because it's very interesting in that it was the first court to be set up by a regional organization, the African Union. And so it's sort of evidence of a potentially new field of international criminal law at the regional level. The history briefly dates back, and a colleague of ours, Ziv Borer in Israel, has written a lot about sort of early international criminal law. So I want to sort of flag that and say there certainly is some pre-World War II era international criminal law, but not much, right? Mostly we trace modern, what we could call modern international criminal law, back to the Nuremberg and Tokyo tribunals. And then we had a long period where not much happened during the Cold War. There wasn't the international agreement available for developments in international criminal law during the Cold War. And really all that happened, or mostly all that happened during that period, was that the International Law Commission at the UN talked about international criminal law and put forward, proposals for statutes of international court, for example. But then once the Cold War ended, we had the establishment under the aegis of the United Nations of the Rwanda and Yugoslav tribunals in situations where very, very serious human rights abuses were occurring and the world wasn't doing a lot to stop them. And so this was seen as, and articulated by the Security Council resolutions that established the institutions, as a way to promote peace and security. Query whether that's actually true, and that's sort of where I'm going with the promise and perils in a moment. And then in 1998, we had the Rome Conference where the International Criminal Court was established. And many of us who were there at the time and involved in that process thought that that might be the last institution building exercise that we had to do, right? That the ICC would take over and be the body that would adjudicate international crimes. Well, it's become amply clear that that's not possible, right? The ICC doesn't have the ability, and now I think there's a lot more recognition that it may not even be a good thing for the ICC to have a monopoly on the prosecution of international crimes. And so there have been additional courts created even since the ICC. Hybrid courts, internationalized courts, like the Kosovo Specialist Chambers, which are dealing with crimes committed in Kosovo, again associated with the dissolution of the former Yugoslavia. So those are the institutions. All right, so that's sort of a very brief overview of what international criminal law is. Let me now turn to the promise of this body of law, the promise for doing good things in the world. The essential promise, in my view, is that of prevention, contributing to the prevention of international crimes. But prevention is a very broad concept and can take various forms. It can be very particular, like incapacitation or particular deterrence of particular individuals. And it can also be very general, including expressive kinds of prevention, right? Expressing norms that then govern people's behavior such that they don't even think about committing crimes. So I'm going to talk about some of those kinds of prevention, and then I'm also going to talk briefly about what I consider a secondary promise of international criminal law, which is restorative justice. And I say secondary because it's international criminal law, which isn't necessarily always very good at restorative justice, criminal law that is. That being said, there are some aspects of international criminal law that do have the ability to contribute in some ways to restorative justice, in particular, the award of reparations and potentially providing some catharsis or other help to victims of international crimes. So starting first with specific deterrence and incapacitation, right? The idea that international criminal prosecutions or the threat of those prosecutions can deter particular individuals from committing additional crimes, or keep them incarcerated such that they don't have the ability to commit additional crimes. This form of prevention is particularly tricky in international criminal law because international crimes, these atrocity crimes, are often committed in situations of armed conflict, ongoing armed conflict, and by government actors. So these are both situations in which it's particularly difficult to arrest and prosecute people because they are often in power in those situations. And so it also, if it's not possible to arrest and prosecute them until after they are no longer in power, then it also may become less important because at that point, they may no longer be much at risk of committing additional crimes once they are out of power. Nonetheless, I think that it's important to think of international criminal law's promise as including this idea that it can deter particular individuals sometimes. And I think there is some evidence that there have been particular individuals who have thought about this when they were in power and perhaps committed fewer crimes as a result of thinking about the possibility of being brought before the ICC, for example, and potentially incarcerated. More generally, though, the idea of deterrence is that the threat of prosecution deters people in the community generally from committing crimes. And international criminal law also has that potential. That being said, it's very difficult to demonstrate deterrence in any setting because you're talking about showing a counterfactual, right? How much worse would things have been? How many more crimes would have been committed but for the existence of the international criminal law or the criminal law more generally? Nonetheless, there have been some studies that have undertaken this challenge and I think have done a pretty good job of showing that there's at least some ability of international criminal law to provide deterrence. And one particularly important study in this regard was by Hiran Joe and Beth Simmons in 2016, where they looked at whether ratification of the Rome Statute of the ICC or ICC actions like investigations, arrest warrants, and so on, had an effect on the rate of civilian killings by government officials. And they controlled for factors like the political regime type that might also impact, most likely would impact the rate of government killings of civilians, and found that there was a statistically significant reduction in such killings when states ratified the International Criminal Court statute, and also that there was a significant reduction in such incidents when the ICC became actively involved in a situation, such as by opening an investigation or issuing arrest warrants. So some positive evidence of a deterrent effect. There's also an important book by Catherine Sickink of Harvard University on a related topic of and she called it the Justice Cascade, kind of catchy name, how human rights prosecutions are changing world politics. The related idea that human rights prosecutions help to improve the human rights situations in countries where they take place. So again, some evidence that these kinds of actions have a deterrent effect, and I think an important aspect of the promise. The ICC in particular has an additional way in which it can prevent crimes, and that is through operation of what's called its complementarity principle and practice. So when states sign the ICC statute, they are obligated to prevent the crimes that take place from taking place in their territory, and also prosecute people who commit the crimes in the Rome Statute if they take place on their territories. And so to do that, they have to adopt national laws that include war crimes and crimes against humanity and genocide so that they can engage in those prosecutions. The ICC also has engaged in something called positive complementarity, where it actively helps states, for example, by sharing evidence and doing trainings and things like that, where it is engaged to have their own domestic prosecution. So complementarity can thus contribute to deterrence at the national level by encouraging states to engage in their own prosecutions, for example, because they'd like to avoid ICC prosecutions, right? They can do that by engaging in their own genuine prosecutions. If the state is prosecuting, then the ICC is not supposed to. And by proactively assisting the states with their own prosecution. So there's another kind of layer at which the ICC can contribute to deterrence at the national level. All of that being said, I don't think any of that is the real promise of the ICC. I think the real promise is prevention through norm expression. And the reason is that the ICC and other international courts can only really prosecute a very small number of perpetrators of these often massive scale crimes. The resources available and the practical difficulties of prosecuting somebody in The Hague for crimes that took place in a country with which the judges are unfamiliar, where a different language is spoken, different cultural norms, all of those kinds of things make it impractical for courts like the ICC to be mainly about deterrence, in my view. But what they can do particularly well is they can express the global community's condemnation of particular kinds of conduct. Now, when I say global community, some of you may be thinking, well, is there really a global community? We could definitely debate that. And if you want to in the Q&A, we can talk about that. And it's something that I talk about in my scholarship. But I do think that there is a global community, at least to the extent that we agree on certain basic norms, including the norms that are at the root of these international crimes. So when the global community engages in prosecutions, for example, through the ICC, arguably also through national prosecutions of international crimes under the principle of universal jurisdiction, the principle that any state in the world can prosecute these crimes because they concern us all, that when that happens, those institutions are speaking on behalf of the global community, and they're also at the same time constituting that community by affirming those norms in a kind of dialogic process with other actors in the global community. They then constitute the community itself, reaffirming values and norms that apply across the board to everybody in the world. So the kinds of norms that can be particularly well expressed by these global institutions include norms that are under-prosecuted around the world or that haven't gotten a lot of attention. And some examples there include the ICC's prosecution of the recruitment and use of child soldiers. That was a crime that before the international courts started to focus on it, wasn't being much talked about at the international level. Certainly some human rights advocates talked about it. It wasn't a huge focus of attention, and it has become much more so. And there's some anecdotal evidence that rebel groups have done less recruitment and use of child soldiers since they have seen that some other rebel group leaders were prosecuted for those crimes at the ICC. Another example is the destruction of sites of cultural importance within communities. The ICC has prosecuted an important case in Mali involving the destruction of Muslim cultural sites there that has garnered a lot of attention for the norm against the destruction of these sites. And maybe most importantly and most visibly, prosecution at the international level of crimes of sexual and gender-based violence, particularly in conflict, has greatly increased the attention on these kind of crimes, and I think contributed to much stronger norms developing. There's certainly a lot more work to be done on this front, but the International Criminal Court's work in this regard, I think, has been very significant and had an impact around the world on these kinds of crimes and the norms around them. Last thing I'll mention is the proposed crime of ecocide. This is a crime that proponents are hoping to bring into the international criminal law sphere precisely for this reason. Not as much, I think, because they envision prosecuting a lot of people for this crime and having specific deterrent or general deterrent effects, but more for this general prevention idea of norm promotion, right? The articulation by the global community of the importance of protecting the natural environment. So important that it's worth the attention of an institution like the International Criminal Court if that becomes one of the crimes before the court. So lastly, I said I would mention something about restorative justice. International criminal law also has the ability to do something in the realm of restorative justice. In particular, there are some provisions, including at the ICC, for providing reparations to individual victims who have suffered from international crimes. And there are some evidence, some possibility that participation in international trials at the international level, which is possible at the ICC, unlike in the US, where victims have a very marginal role in criminal proceedings. At the International Criminal Court, they can participate actively. They are represented by counsel. Their counsel can be involved in bringing witnesses, cross-examining witnesses, bringing evidence. So that participation has the potential to be cathartic for victims and potentially contribute to healing and perhaps even to reconciliation, peace, broader general social reconciliation and restorative justice. Okay, I'm going to turn now to the perils. One of the most important, maybe the most important, is that international criminal law can reflect and perhaps reinforce power differentials, global power structures that are unfair. So powerful states, as you know, insulate themselves from international criminal prosecutions. And the International Criminal Court's jurisdiction is circumscribed. Right? It has jurisdiction over non-state parties only, excuse me. It has jurisdiction over non-state parties only when the Security Council refers a situation to the court, okay? So otherwise, either the state where the crimes occurred or where the defendant is a national have to be parties to the statute. But if the Security Council refers, they can refer a situation involving crimes anywhere in the world, except, as you can imagine, the P5 states, because each of them will veto any referral of crimes occurring on their territory or on the territories of their allies. Right? So that's a big weakness of this regime, that it operates within these power structures and perhaps arguably even reinforces them. Powerful states have sometimes even actively fought against ICL, and our state in particular has fought against ICL in some of the most intense ways. In particular, under the Trump administration, there were sanctions issued against the prosecutor of the International Criminal Court. And as a side note, I was actually a plaintiff in a lawsuit against Trump and others for that, because what that meant was that those of us who might support the ICC prosecutor in some way, including perhaps by, giving some advice or acting in our academic capacities in a way that supports the ICC, could ourselves be targets of sanctions. And of course, you can easily see that that was a very novel and questionable, to put it very mildly, use of the sanctions powers, which were created and have typically been used to discourage people who were engaged in grave human rights violations, not those who are engaged in prosecuting people for grave human rights violations, like the ICC prosecutor. So there are tools like that powerful states can use to fight international criminal law. and that weaker states just simply don't have the ability to use. And I'll give you another example. A few years ago, Belgium had a very broad universal jurisdiction statute. And as I mentioned, universal jurisdiction gives any state the ability to prosecute international crimes that occurred anywhere in the world, even if there was no connection between the state and the crimes. And so a Belgian judge thought it would be a good idea to seek to prosecute an American general for international crimes. And that very swiftly changed Belgian law. The US quickly put pressure on Belgium, and it changed its law to narrow the scope of jurisdiction to require presence of the defendant, so that it was not possible to try somebody with which Belgium didn't have that kind of a connection. So power is very much at the heart of what's happening in international criminal law. It's important to talk about that and to face it in order to address the possibility of that power imbalance in the way that affects international criminal law, really strongly undermining the system. Some people say that it already does. Christine Schwebel, who's one of the main critics of international criminal law, has argued that the fact that European states and some other powerful states fund the ICC insulates them from its attentions. So the way that money flows, right, is clearly an important determinant also of how decisions and actions are taken. Another really important peril of international criminal law is that the focus on individual criminal accountability can distract attention from other causes of harm. So systemic inequalities can be ignored because we're focusing on holding particular people liable for international crimes. Karen Engel has written quite a bit about this, and so I'll quote her. She says, advocates of international criminal law, that is, might also begin to conceive of the broader issues they promote as criminal issues, as though their victories in punishing a few bad actors could address centuries of biases based on race, class, and gender, thus relieving pressure on the state to attend to the structural issues of distribution. Right? Really important potential peril of international criminal law. Additionally, scholars have pointed out that the focus on individual actors may distract attention from the need to hold state actors and states themselves responsible, and potentially even entire large groups of people, right? Sometimes we think of people as bystanders. If you know anything about the mass atrocities committed in many parts of the world, you know that there are a lot of people involved other than the direct perpetrators of the crimes, right? We sometimes call them bystanders. And Marty Kostianiemi wrote in this vein that individualization may serve as an alibi for the population at large to relieve itself from responsibility. Another peril. Corporations are not the subjects of international criminal law at the moment. And as we know, corporations are deeply involved in responsibility for some massive human rights violations around the world. So again, does this focus on individual criminal actors distract from that and take attention and resources away from solving those problems? Prosecutions are often one-sided and therefore create a narrative that may be a false narrative about what happened in a conflict or a situation because they focus on one side. That may be because the only way to prosecute anybody in the situation at the international level is to have the cooperation of the government. Without that cooperation, investigators aren't going to be able to go in and get evidence. Witnesses aren't going to be able to come and testify. And that sometimes has meant that the government's own misdeeds, the misdeeds, the international crimes of government actors go unprosecuted, thereby creating a narrative of what happened that isn't accurate. And also unfairness in terms of the distribution of justice. Another potential peril is actually harming societies through the what we sometimes talk about as the peace versus justice debate, right? There's some evidence that at least some of the time, engagement in criminal prosecutions undermines peace processes. And this is debatable. This is my opinion. I think that there's some evidence of this and that it's something that we need to pay attention to, that we shouldn't just say, oh, no, ultimately peace requires justice. Well, that may be true, but that's in a longer time horizon. And sometimes we need peace really quickly. We need it now. A lot of people are being harmed very badly, and we don't have time to wait for criminal justice to work its way out. We need people to step out of power now. And if they're under an arrest warrant, they are much less likely to do that. There was one empirical study that found that the involvement of the ICC correlates positively with the onset of peace negotiations because the leaders are incentivized to engage with the ICC and show that they're doing something productive at the national level, but that it correlates negatively with lasting peace because once the ICC issues an arrest warrant, the leaders have an incentive to stay in power. And we saw al-Bashir in Sudan stay in power for a long time, Gaddafi in Libya try to stay in power, Gbagbo in Cote d'Ivoire, the LRA, Lord's Resistance Army rebel group. There's some evidence that the leader, Joseph Kony, once the arrest warrants were issued against him, held on to power and disengaged from the peace process. So that's a very serious peril as well. Last peril that I'll mention, I know I'm just about to wrap up, is that the anti-impunity agenda, framing these issues as issues of criminal responsibility, can take away attention, this is something that I've been thinking about more, from the issues of human rights related to criminal law and carceral states more broadly. And I'll quote Karen Engel here again, because I think she says it well. The alignment of human rights advocates with the carceral state cannot help but affect the extent to which the human rights movement is able to mount a serious criticism of mass and brutal incarceration and the biases we see in nearly every penal system in the world. So another important peril to think about. So let me end on just a few words about what I see as the future. I think that for me, the promise of international criminal law outweighs the perils. So I'll put that out there. I mean, I think this is something that can be debated and is being actively debated among commentators, activists, and scholars who think about these issues. And for me, at the end of the day, some global criminal justice is better than the alternative. That being said, I think we need to do more to embrace alternative justice mechanisms and bring those into the attention, into the scope of what the global community thinks about in the context of mass atrocity crimes. Doing more than we have to put resources and attention into things like Truth and Reconciliation Commissions. Colombia is doing some very interesting things as part of its peace process to incorporate restorative justice alongside criminal justice, and I think we can learn from some of those efforts. And we need to fight harder against the unfairness that comes from the imbalances of political power and the inequalities that that creates. We need to fight harder in lots of different fronts, including things like Security Council reform, well beyond the scope of my talk, but the fact that we support international criminal law for those of us who do doesn't mean that we don't also agree that we need to find better and more ways to address these imbalances that cause international criminal law to be less effective and less legitimate than it could otherwise be. So I'll end just by saying that I think that international criminal law should be part of a bespoke approach to justice at the global level, and that by engaging in that process, we continue to build and together with all of the different actors in the process, including civil society, including academics, including government actors, as well as the actors in the institutions themselves, we are co-creating a global justice system that ultimately holds a lot of promise to do good in the world. Thank you.
Well, thank you so much for that incredible and fascinating lecture. So before we go to questions, I think, want to make sure I have the order. Yes, so we were talking before when you came to my office. We had a comparative office discussion in which I believe you reflected. Yes, yes, reflecting the opinion that my office might compare favorably to yours. So, but we're going to fix that because we have something for your office right here. So I want to present you with this and yeah. Hey. Okay. And so I was going to start off with the first question, and then we'll open it to the audience. So I was interested in your discussion of norm promotion and the idea that that could be sort of maybe the primary function of the ICC is simply by recognizing crimes at the ICC that could have an impact even without trials. And you mentioned ecocide, and I'm interested. That's something I've been working on. And as you know, I always I happen to agree with everything you say. So it can be hard to find challenging questions. But I was thinking from the norm promotion perspective, there is this issue is that there's all kinds of norms that we would want to promote. Some of them are the kinds of norms traditionally associated with international criminal tribunals, but there's all kinds of other norms as well. And so if that is the function, what would then be the criterion for deciding, like which norms should be promoted through like a human rights treaty, right? Or something like that. And is there something about international criminal law specifically where we would have criteria for, what we want to include at the ICC? Or would it just be, hey, if if there could be a positive effect from it, then we should include it, if that makes sense? Yeah.
No, that's a great question and something that I've thought a lot about, and I actually have addressed it a little bit in the book that you referenced on gravity. I actually don't think that there's anything very I know you're writing about this too, so we can have more conversations about this, but I think I have a hard time agreeing that there's anything very specific about international crimes that differentiates them from other crimes. And as you know, a lot of what people talk about in this regard relates to the gravity of the crimes. And I spent a long time in that book sort of dissecting that idea and ultimately saying it's not that great of an idea. It doesn't really hold up to intense scrutiny. So I think that I fall back on this idea of a dialogic process, that what's really happening or should happen is a conversation at the global level about what is the appropriate subject of international criminal law. And that conversation takes place in lots of fora, right? It's taking place right now, the Sixth Committee with regard to crimes against humanity. It takes place in treaty negotiations. And I think that process will be sufficient to make the distinctions at the appropriate times. I think right now that's happening with ecocide in the sense that people are going around talking about, oh, ecocide should be an international crime. And other people are saying, oh, we're not so sure. And that's the dialogue that ultimately will resolve the issue.
Thank you. So we're going to turn to audience questions, but just one word of caution, and you can correct me if I have this wrong, but Professor deGuzman is a sitting judge, and my understanding is that she is not planning to comment on specifics of active situations, or if there's somebody that you have in mind that you think, why isn't so-and-so being prosecuted for genocide, if you ask the question, you're not going to probably answer things like that, because that would not be appropriate. So, okay, questions. Yes, over here.
Thank you for being here. And I don't know if you can answer this question now, but So today we're seeing in China, Uyghur Muslims being forced into forced labor camps, in part making products for multinational companies. We're seeing thousands of Yazidi Christians in the Middle East being forced into sexual slavery. We're seeing the Burmese military force Chin Protestants into persecution as well. We're also seeing the slaughtering of Christians in Nigeria. So my question is, what teeth, if any, does the ICC have to protect religious and ethnic minorities from persecution from either government actors or from other actors?
Yeah, it's definitely a fair and certainly related to my remarks. I think we are definitely seeing lots of examples of persecution along those lines. And if you look back historically, we pretty much have always seen that, right? So the ICC is not an enforcement body. It doesn't have, it can't intervene to stop these things directly. The best that we can hope for are some of the things that I was talking about in terms of norm promotion and maybe some deterrence some of the time when the power structures align in the right way and all of that, right? So I wish I could say that there were more that the international criminal law regime and its institutions could do about these things. But I think part of my message today is that we shouldn't allow that regime to distract us from the other work that needs to be done through, politics, diplomacy, maybe intervention, under R2P, if you subscribe to that, things like that, should continue to be very important foci of our attention.
Hi, thank you. My name is Madison. What impact, if any, would a strong ICJ opinion have on state duty to the environment with the advancement of this ecocide question? Would a strong positive obligation of specific duties and aid in the establishment of ecocide? And then would there be any interplay between clearly defined liability in terms of due diligence obligations and good faith in terms of environmental obligations to the ecocide conversation?
Yeah, thanks. Really interesting question. The relationship between the International Court of Justice, which of course is a court that adjudicates disputes between states, and the International Criminal Court or other institutions of international criminal law. I think your question goes to what extent can decisions by the ICJ influence the development of norms of international criminal law, like this idea of ecocide. And I think they can, in the same way that I was talking about with Professor Greenewald about this dialogic process that I see as sort of the way in which these things evolve, right? The ICJ decision is part of that conversation. But, and an important part, I mean, those are very respected judges and that court has a lot of legitimacy. And so I think that it's an important part of the conversation. It's not going to directly influence, right? Because to have the crime of ecocide included in the ICC statute, the Assembly of States Parties has to adopt it into the, modify the Rome statute to include that. That's a whole different process that has nothing to do with the ICJ. But this norm promotion elaboration project goes beyond the ICC and includes the ICJ in the broader sense, in the broader conversation.
Professor Rink.
Oh, thank you very much. Hi, Professor Paul Rink, and thank you very much for your talk today. I wanted to say first off that I am very sympathetic and tend to agree with you that ICC's biggest impact is in its norm establishment. And you highlighted some of the positive norms in your speech and also some of the potential negative norms, including things like general sense of impunity for very relatively powerful nations to get away with crimes against humanity that other countries may not, as well as the tendency for authoritarian regimes to remain in power as to avoid liability. And I was wondering why you're optimistic about the positive norms outweighing the negative norms. And that might be a longer conversation, but maybe to abbreviate, if you have things in mind about how you could attenuate or mitigate some of those negative norms so that the positive norms outweigh them.
That's a great and very challenging question. I think the short answer is I'm optimistic by nature, so that's not a very satisfying answer. But I also think that we've seen some really positive impacts of the ICC in the short time that it's been around, and of the ad hoc tribunals, the Yugoslav and Rwanda tribunals as well, have developed. If you take just the norms involving prosecution of sexual and gender-based violence, they have evolved tremendously through the jurisprudence of the courts, through the practices. The courts have influenced not just the development of the law, but they have encouraged many more prosecutions than would otherwise have happened at the national level, and the prioritization of those. And they have influenced the ways in which those prosecutions are conducted. So for example, the protection of victims and witnesses at the international level, there's some ability of that to trickle down, particularly in states where the ICC is actively engaged and maybe doing some proactive complementarity, positive complementarity kinds of things. So I guess the other part of my answer would be that I don't think the challenges, the perils, are things that largely relate to the structure of the global system. They're not created by international criminal law. They're there, and international criminal law is fitting into that system. And so I don't think that, we can sort of entirely blame international criminal law. I do think there is some potential, as I said, for it to reify or, sort of make some of those inequalities worse. And those can be, at least some of them can be addressed. There are ways to do that. But I guess in terms of the ultimate question, I think that having some international criminal justice is better than none, which would be the other option, right? If we said, well, the system is so unequal, so imbalanced, the US and Russia are not going to allow prosecutions of crimes that took place on their territories, so we just shouldn't do it, then we'd miss out on all the other benefits. And I think that would be the wrong call.
Okay, I think we're going to do one more question. So we unfortunately can't, so Professor McDonald, but I just want to mention we are going to have a reception afterwards. Professor deGuzman does have to leave to go back to Philadelphia to teach this afternoon, but
International criminal law, actually.
international criminal law. But I believe we'll be available for a little bit after after the formal session is over, if you have questions for her.
This was a perfectly nuanced lecture. Thank you. I just wanted to mention something we discussed beforehand, and that you mentioned the expression of condemnation, establishing norms is the greatest contribution the ICC, for example, can make. And yet, Thomas Lubanga only received a 14-year sentence for recruiting and using child soldiers, a crime that scars these children for life. And also, as you know, child soldiers are the most dangerous. They tend to commit the gravest humanitarian violations because they're immature, they act impulsively. So I'd like you to address that, if you would.
Sure. Yeah, we were talking about this because it's something that I have focused on in some of my scholarship, is what is the appropriate punishment regime at the global level? As you can imagine, when these courts were created, there wasn't any global punishment system or any norms at that level, right? So they kind of had to make them up, starting with, well, in Nuremberg, a lot of them were hung, right? Some of them got life sentences. But then at the ICTY and ICTR, they had to figure out what the appropriate norms were. And if you just looked at the norms in former Yugoslavia and compared them to the norms in Rwanda, they were vastly different. Punishment norms in those national systems were vastly different. And the international courts were seeking to create something different again, right? Which is something that would be a cohesive idea of punishment at the international or global level. And so they've received a lot of criticism, the ICC in cases like Lubanga, also the ICTY for some of its sentences that were perceived as very lenient. My view of that is that because there are no punishment norms at the global system, we should be very careful about how we establish those norms. And I think about punishment in this country as being very linked to ideas about retribution, right? Deserved punishment. What does somebody deserve? And in order to scale punishment in a retributive sense, you have to have some anchors. You have to know what the norms in the society are, the punishment norms for some crimes, so that you can fit this crime into that scale, into that spectrum of deserved punishment. And here we have what other countries consider very draconian punishment norms, right? We are at one end of the spectrum in terms of how severely we tend to punish people convicted of crimes. In other parts of the world, punishment for a mass murder in Norway of, you'll be familiar with the case I'm thinking of, I think it was 21 years, was considered appropriate. And this was a mass murder of youth political activists. And that was considered the right sentence, right? So we have this problem that we have these widely divergent norms. I think the best thing to do is to be very careful not to set any anchors in if you're thinking retributively. I tend not to think retributively, but if you're thinking retributively, I think you should be careful to set the anchors lower rather than higher, right? So that you're not punishing. I think it's more dangerous to punish somebody more than they deserve than less than they deserve. That's one thing that I would say. The other thing that I would say is I tend to think about punishment more from a utilitarian standpoint. What good is going to come out of it? And because I think that a lot of the good that comes out of the ICC is the norm expressive function, which primarily comes from the actual process of arresting, trying, convicting somebody. I think it's less importantly from the sentence part of it. I don't think that garners the kind of attention among non-experts that the actual process and conviction does. In that sense, I don't think that the punishment is necessarily as important to the utility of the court's work as it might be in some other contexts. I hope that's responsive.
All right, well, thank you so much once more. It was great. And so that concludes our lecture. I hope people will linger and enjoy the reception.